we sent out a survey to our members, to you, asking you for questions and concerns regarding fair housing, ADA, and disparate impact. And the responses we got back were many, so thank you very much for those questions. Those questions you will hear as part of this discussion today. But what was really amazing was the fear, the frustration, the confusion, and sometimes a little bit of anger that were the emotions that were expressed as part of those responses. Well, we are very fortunate today to have two terrific attorneys from Fennemore Craig who graciously brought themselves here to answer some of these questions and to give you tools so that you can practice your business and serve your clients well. Bruna Pedrini served as Chief Counsel of the Civil Rights and Conflict Resolution Section of the Arizona Attorney General's Office. She's helped builders, developers, colleges, restaurants, large sports and entertainment venues, and hotels comply with federal, state, and local requirements and represents them in ADA and fair housing litigation. Alexis Glascock has worked in private practice as well as in state government. She has served as counsel to the President of the Arizona Senate and assistant to the General Counsel of the Legislative Council. She has experience drafting and modifying legislation. She gathered experience at the federal level with the majority leadership of the Joint Economic Committee of the U.S. Congress. In that role, she selected witnesses to testify before the committee and authored a 3-volume series on the economic impact of women in the marketplace. So please help me welcome Bruna and Alexis. Well, thank you both for coming. We really appreciate it.
Sure. Thank you.
So we're going to start with a pretty general question just to get the conversation started. Maybe a quick 2 or 3 minute, because it's so vast, overview of fair housing, what it was designed to address.
Sure. So I guess we can take that. So fair housing is, first of all, thank you all for the opportunity to be here. Fair housing is actually something that is pretty near and dear to my heart, so I always appreciate the opportunity to speak about it. So fair housing, as you all know, is basically, it's a civil rights law, and it was established to try to deal with the opportunities of persons to be able to live where they want to live, regardless of their protected class status. And so fair housing addresses any kind of real estate transaction that you can have. Really, it is incredibly broad. So it covers any residential real estate, from a vacant piece of land to multifamily housing to single-family housing. It involves everything from banking, which most people often don't think about, the lending aspects associated with fair housing. Insurance is covered under fair housing. And then obviously, the buying and selling of real estate that you are typically involved in. It also involves advertising. So it is incredibly broad in terms of what it covers. And it also means that the people that are covered under the fair housing laws, it's incredibly broad, the breadth of it that way. So you are covered in terms of the number of plaintiffs that can bring a fair housing claim. It's incredibly broad. Almost anyone can be caught up and bring a fair housing claim, because it can be a person that feels that they were discriminated against in a residential transaction, or someone that is associated with them can also bring a claim. And then in terms of who can be a defendant, it can also be virtually anyone, because agency law is very, very broad under fair housing. So that means that you as a real estate agent or a broker can have a claim filed against you. It could be a banker, it could be an insurance agent or someone like that, and it can also be anyone up the chain in terms of who you're involved with. So anyone like that can be involved in a real estate fair housing claim.
Redlining, steering, and block busting became part of real estate insurance and lending because of HUD underwriting guidelines under the New Deal in the 1930s.
Okay.
Aren't we going back there with the affirmatively furthering fair housing map?
Yes and no, I would say. So you're going to get a lot of kind of talking answers from me on this. So redlining, and first of all, I think we should talk a little bit about what redlining and steering and blockbusting are, and really what they meant and how they developed. So does everyone know what those are? Some nods and heads, right? So just to go over those. So redlining is when you can redline in or you can redline out people. So redlining is when you create an area and a bank or an insurance company in particular will, even though they have designated an entire area as being their service area, they will actually not provide service to persons in an area, or they will just provide services in a specific area. Okay, so that is redlining. They have drawn a red line around the area that they want to provide services in, usually, and they will provide different services outside of those or no services at all outside of those. Okay, steering is obviously when you decide, or someone who is providing real estate related services decides that they are going to make a decision for the person who is the purchaser or the person looking for credit, and they steer them toward a particular service or a particular home or a particular neighborhood, right? So you are pushing a person toward a particular product, whether that product be a house or an insurance product or a lending product. And then blockbusting was when people would come in and say, you don't want to live in this particular neighborhood, for example, because XYZ group is going to be living here, right? So you don't want to be here. The neighborhood is changing, and so you want to, live somewhere else. So those are what those terms mean under the fair housing laws. So when we talk about affirmatively furthering fair housing, one of the things I want to make sure that everyone understands is that the law really hasn't changed in that regard. The affirmatively fair housing regulations, or the rules that everyone is talking about now, have been part of the statute forever. I've been doing this personally since '94. It's been around since '91. It's been there all along. What the regulations did was to make more clear that there was going to be enforcement, and what those standards would be. So I would say that it is not so much that we are going back. It is more that there has been some clarity in terms of what these rules mean and what they always meant under the law, and then whether or not they are enforced is anyone's guess, right? So is that clear as mud? Right. And please ask, I don't know if that's okay, but if you have questions, interrupt me, because I'm a good Italian, so I'm used to being interrupted whenever, so it's fine.
So if you're unfamiliar with the Furthering Fair Housing map that HUD put out, you can go to wemargad.org, and we have that map there. So you can go in, it's an interactive map, and you can zoom in and look at it. I think one of the concerns that was brought forward with this was that map has colored dots that designates particular types of people and where their concentrations are. Right. So one of the concerns was with them coming in and doing that, are we allowed, if it's an orange dot person technically that we're helping, do we have to not show them a house in an orange dot area if that's where they want to live because there's too many orange dots? That's what we were hearing in terms of we want to make sure the population spreads out. So that's where some of, so can you help us with how absolutely. We negotiate that issue?
So the idea of knowing where people live, right, where people have already concentrated, is not to say that you can't show someone a home if that's where they choose to live, right? So if they're saying, this is where I want to be, then that's fine. That person can go there. But it's not pushing them there and giving them also other alternatives. Okay, so because a lot of people tend to go only where they have received advertising, or where there has been information given to them, or what they already know is available. And so part of that is being inclusive. So the idea, again, if you think about the terminology, affirmatively furthering fair housing, the idea is just to widen kind of the map, right? And to say, this is not, you can't show someone a house in this area, but show them housing also in other areas where their dot might not otherwise be. okay? So you're not going to get in trouble if the person says to you, but I want to live next to my mom and dad, okay? That's fine. But for example, I did fair housing, right? I enforced fair housing at the AG's office. And for a long time. And when I went to look for a house, my husband and I, somehow the realtor, even though they had my card, decided they knew that I was Christian, and or thought that they knew that. And so that we were looking at a particular neighborhood, and they said, well, you know, I'm not sure you should know that you might not feel as comfortable here because, you know, they refer to this area as the Rose Garden. And I was like, really? Why? And they were like, well, you know, because there's a rose in bloom on every corner. I was like, seriously? Okay. Like, so let's like back that up just a second, right? So, so it's that you don't want to do. It's like you don't want to do you should go here, right? Which is part of, that's not affirmatively furthering fair housing. That's part of steering. Okay. So really used properly and enforced properly, and I can't tell you that everyone will do that. Okay. So I understand that some of the fear, but the idea behind knowing where people already are is just to say you don't have to show people just in those areas. You don't have to have those concentrations. Okay? Great. So,
I have a question.
Sure.
How does all that pertain to places that would be known violent areas?
all right. Well, so known areas of crime.
Violence.
Yeah, of violence. So if a person says, I don't want to live in an area of crime, right? That's fine. I'm not aware of any class of person that wants to live in an area of crime. So I've never heard anyone say, you know, I'm looking for a house somewhere where there's a lot of crime. Right? That would be, yeah.
I'm talking about
Yeah.
the realtor that knows that an area is riddled with crime.
Sure.
And the buyer would have no idea about that. That's what I'm referring to.
Right, and so for example, so I always say, like, you can describe the property, right? And you can describe, and you can talk about crime statistics, but you don't describe the demographics in terms of the people who live there. So the assumption that because a neighborhood, for example, has more people of color, will have a higher crime rate, is not, you don't want to make those, connections, okay? So, and that's what you want to be, wary of. And so if you're being, and usually what you do with the like crime areas is that you point people toward, again, the public documentation that says, this area is, has some issues like that, or it's developing, or it has, whatever, kind of terminology you want. And usually if they drive around, they will have a good idea of, what the area looks like.
There is a website, crime reports.
Right, exactly, right.
I just give it to my clients, let them go look it up.
Yeah, exactly. So it's not usually, but again, you're always describing kind of that rule of thumb, and you guys know this because, you've been doing this for a while, right? It's like you're always describing the property, or like you're not describing the person who should be living there. And that's what affirmatively fair housing is about. Okay.
Yeah, one question.
Give me the name of the map again and where it is.
Oh, it's, okay, the Furthering Fair Housing map. HUD released it, and you can get the link off of wemargad.org, wemargad.org. Under regulation, we have that map. I want to go on to, we have a lot of subjects, so can I go on to service animals real quick? Because I know we have a lot of property managers, and this is really something they were concerned about.
Okay.
All right, service animals. What is the difference between a service animal, an assistive animal, therapy animal, comfort animal, and which ones do residential landlords have to allow? That's the first set of questions. We have a lot of these.
We have a lot, yes.
I'm going to chime in on this one.
Yes,
I'll
exactly.
take the lead on this one. And just so everybody knows, I have a little bit of a cold, so if I start coughing, excuse me, I'll just step out for a minute and come back. But so with regard to the service animals, basically their service animals are different from therapy animals. And a service animal is a dog who has been trained, and in Arizona it can also be a miniature horse. An animal that has been trained to perform a specific task. And so, for example, A dog might pull a wheelchair. It might be a dog that is held close because it's detecting the smell of somebody who has diabetes and might be having sugar issues. It could be, any number of things. Somebody in a wheelchair who might drop something, the dog retrieves it. That is a therapy animal. Whereas a comfort animal is an animal that is for the person's emotional well-being or psychiatric issues, but it's not because they are not able to function. Given their disability, the animal is helping them to, is assisting them in daily living. So those are the differences between the two.
Okay. And which ones do residential landlords need to allow, or which ones can they say no to? Right.
So residential landlords can, if it is a service dog in Arizona, the landlord needs to allow if the dog is, so basically there are some restrictions, but overall, if the dog is a service animal, they may be allowed. If it's a comfort animal, they may also be allowed if it's housing. And in this instance, however, if the dog creates problems such as it's incessantly barking, or it's going to the bathroom in the unit, or is damaging the property in some other way, the landlord can then assess a fine. If the dog is creating noise issues, then that's an issue for local ordinances. But the landlord has to accept both service and emotional comfort animals. However, a landlord can have in their lease, that they have to pay for any regular damage that's caused, and it would be damage that would also be caused by anybody else.
Okay, just so we get some clarity. So if someone describes their animal as a service animal or comfort animal, landlords need to let them. But assistive or therapy, because those other terms we hear people describe their animals.
Right, and there's a lot of issues with this.
Yeah.
The assistive and the therapy animals are not, if they are trained as a service animal and they are assisting a person with a disability, then they have to be allowed in. If they're an emotional animal, that is just providing comfort, but it's a place, not a hotel, but it is a place that's being, lived in. Then it has to be allowed. It also has to be allowed. So, and Bruna, maybe you want to chime in on.
Yeah. So the confusion, I think, becomes because we have under the ADA there's one definition, right, and then under the fair housing laws there's a different definition, and so if we start with what Alexis is talking about under the ADA. There are, and those goes to places of public accommodation, right? So any place that the public can go, and that includes your, the offices and the like for your rental offices and all of that, and hotels, or if you have long-term places that are part of your residential developments, like if you have housing that you are letting people stay in for longer periods of time as part of your property management, that can qualify as a place of public accommodation. In those instances, the only animals that are there are service animals, okay? And service animals are just dogs and miniature horses, like Alexis was saying, okay? And for those, there are the specific questions. The only two questions that you're ever allowed to ask are, what does this dog, help with a disability, right? And what tasks exactly does this dog do, okay? Under the fair housing laws, the definitions of the animals that are allowed is much, much broader. So there you can have everything from a service animal to a comfort animal to a therapy animal to what they call assistance animals, right? So the entire spectrum is allowed. And if you think about it, the reason for that, as Alexis is alluding to, is that you're in someone's own home, right? So the animals that a person can have with them are much more. So literally, you can have an assistant iguana, right? We have seen, assistant birds and all sorts of different things that can be so in fair housing, you have to allow virtually anything, but it still has to be connected to the person's disability, okay? So it's not every animal, and I believe, as we've discussed, that some of the issues have been that people are bringing in every kind of animal and claiming that it's an assistance animal, and that's not true. While every type of animal could be an assistance animal, not every animal is an assistance animal. Does that make sense?
Excuse me, do they register or certify these service animals, so there's any kind of documentation?
No.
No, they don't have, no.
Anyone can find their
And there are a lot of services, there are a lot of internet services that provide documentation, but it's not authentic. The dog or the animal does not need, if it's a service animal, does not need a collar, any type of identification, or a vest. And as Bruna indicated, there's only 2 questions you can ask. Is your dog a service dog, and what tasks does it perform? That's the only questions. But in housing, you have some additional issues, such as, perhaps if it's a rental unit, then you're going to have dander and other things that might be an allergen. But under the fair housing, that is not a reason to restrict it, even if your property is a no-pet property. If they come in with one of these animals, you're going to be required to let them bring it.
Right. So the thing to look at there, though, is that even though the animal itself, it doesn't need to be certified, you can ask questions related to its connection to the disability, right? Because in fair housing, the assistance animal is still a reasonable accommodation. It is something that is allowed. It's a reasonable modification to policy. So you have, so pets are not allowed. Okay, that's fine. But assistive animals are allowed under the fair housing laws. And so the reason that they're allowed is because the person with a disability needs that animal in order to be able to live in that housing. So there still has to be a connection to the disability. So the animal doesn't need to be certified, but you can ask for documentation that is related to the disability. And what you're getting on the internet, those just one-liners that say, oh yes, this person needs it because in very, very broad terms, it's connected to, oh, it gives them comfort or it gives them whatever else. Those aren't sufficient. Okay, it actually needs to say, yes, this this dog or this iguana helps with this particular situation. This is what this animal does. Okay. Yes. I mean, we should call it.
Back in 2006, when we started coming up with this conglomeration of assisted animals and companion pets, the State Attorney General's office said for a companion pet to be accepted to residential and rental units, the owner has to have a letter signed by a medical doctor.
Correct.
Is that still effective?
Yes, and that's what I'm referring to, is that you can ask, they don't have to have it, okay, but you can ask for it. So if someone wants to let in an assisted animal without that, that's fine, okay? But if you and the caveat there is, if the disability, and this was the case even in 2006, if the disability is obvious and the way that the animal helps is obvious, then you don't ask for the letter, okay?
For example, if somebody is visually impaired, you can tell that, you cannot ask that question.
Okay. But if you can't tell what the animal is being used for, then you can ask for that documentation.
But like companion pets, you got somebody that says, I gotta have this cat in my lap.
Right.
For emotional stability,
Right.
the Attorney General's office said you gotta have a letter from a doctor.
Correct.
Saying you have to have that companion pet.
Right, again, you don't have to, but you can ask for that. Exactly, you can ask for that.
So going along with that, so with the animals that we've now identified, for people who are showing houses, and is it okay for them to allow their buyer with that pet to enter a house that's been listed on the MLS when the owner of the house may not want animals in their house? So how do we negotiate the accommodating of the animal and the person while we're trying to show a house with a homeowner who maybe they have allergies to cats, so they don't want that person with a cat in their house. So how do we accommodate that?
So really, you can only exclude a service animal from any public area if they would fundamentally alter the nature of the service or the program, or if the animal handler cannot control the animal, or doesn't take, or it's not housebroken. If they don't take effective control over the animal, or it's not housebroken. But other than those instances, they cannot. Even if the homeowner prefers not to have somebody, they've got an allergy, their kids have an allergy, that's not a viable reason not to allow
So
the.
once a house is listed on the MLS, then for that period of time, it comes under public accommodation rules is what we need to understand is, okay.
We have two, right? You've got
Okay.
both. Because keep in mind that once you trigger, fair housing is triggered instantly the minute you use a realtor,
Okay.
right?
Yeah.
So even if you have a single-family dwelling,
Right.
right, which normally wouldn't be covered under disability,
Right.
you are instantly triggered the minute you use a realtor. So anything in fair housing is triggered when you use a realtor.
Right.
Because you're advertising. So now, and then the portion where you're showing it,
Yes.
right, is more akin to public accommodations, right? So,
Yes.
Excuse me, I was in a class last week, and everything I'm hearing today is different than what they said in class last week. Thank you very much. In the class last week, they said if a landlord has a property and they have tenants in it, 2 tenants, and in the lease it said no pets. Okay, but one of the tenants has a friend who wants to come visit them with a service animal. Last week they said in the class that that friend could not visit them with a service animal because of the lease. True or false?
False.
False.
That's last week they said true, so thank you very much.
Yeah. And the reason for that, I mean, is because you cannot keep out the service animal, right? I mean, that would just be, even though it's under fair housing, because that's not public accommodations. But the animal is, it's a visitability issue, and no pets doesn't cover. I mean, whenever you hear someone say, the service animal can't go because there's a no pets policy, okay? And you can take this to the bank, and you can tell whoever taught the class, they can come talk to me. I'd be delighted, okay? Okay, good. All right. All right. If the
You'll be getting a message.
Okay, that's fine. If they are saying that the reason for it, and I'm betting that there's a caveat, but if the reason for it is a no pets policy, the answer is no. Okay? There can be something else, right? But if it's a no pets policy, that cannot keep out a service animal.
Okay, so for those of you who are
So-
taking listings, understanding now that putting that house on the MLS just turned it into public accommodation for these purposes, you might want to have that conversation with your property owner during that listing agreement, so they clearly understand what is going to happen when we show properties. That's a great,
And that's only for a service animal.
Yes,
Right.
service
So we're just talking about if someone comes in with a well-trained service animal, right? So you are talking about a dog, right? Because you're not going to get a miniature horse, right? I mean, if you do,
probably.
if you do, you're going to be on TV. It's going to be awesome. You're going to show the house. You're going to sell it, right? It'll all be great, right? So it's all good, right? So yeah, but if you have a well-trained service dog, that dog is going in. That dog can go into the hospital room, right? That dog can go in anywhere. So if you've opened your home to show it, denying that means that you're denying that person the right to purchase your home, right?
but comfort
yeah.
animals,
Comfort animals, yeah, no, I'm gonna, because that goes into if they're living there.
thank
yeah.
you. Okay.
And I do want to mention
got
one
a
other,
person there,
oh,
yeah.
go ahead.
Yeah.
Going back to what a landlord can request from a person with a disability, I'm going to use a specific example because I wasn't really clear on that physician's letter and how far you could go with that. So if you have a client who's diagnosed with PTSD and they have a service animal who's trained to block, to create a space barrier for them and trained to keep them calm, so basically disrupt anxiety attacks and focus. So it's not a visible disability, so the landlord then asks the person, is that a service animal? And the potential tenant says yes. What is this animal trained to do for you? They list those 2 tasks. Can the landlord then say, I will need a letter from your physician?
Yes, in housing, yes.
So this goes to,
just
I'm
in
sorry,
housing.
before you answer, because some people may not have heard of it up here. So this goes to a specific example of a time when the question was, can they request that letter and to get it? And that had to do with a position where someone had a service animal. It was trained to give a barrier around the person for anxiety purposes. So that's something you can't readily see. Can that landlord ask and actually sort of require that doctor's letter in order to verify that? And the answer is
Yes.
okay, great.
Because it's PTSD, right? So you can ask. I mean, and you don't get to, there are limitations. You don't get the entire doctor's file, right? There are, you know, you don't get to know everything about them, but you get to have a doctor's note that says, my patient has a condition, and they may explain that it's PTSD, that requires an assistive animal or a service animal, and this because the dog does X. Fine.
Okay, we have a couple other issues I want to try and get into this hour as well. So we had some questions from agents who are bilingual or multilingual. So the first question we had was from an agent who said, is it okay for me to put a sign writer in a language other than English in order to show my expertise? So she was bilingual. She had her regular brokerage sign for ABC Realty, the phone number, that type of thing. And she wanted to put a sign writer up, in this case in Spanish, to let people know she was bilingual, she could help them in either English or Spanish. What can she do? Can she do that? She was afraid to do that because of fair housing.
Okay. Alexis's throat is hurting, so I'm gonna.
It's fine.
So I'm talking a lot for her, but otherwise she would talk. So a bilingual agent, yes, they can put up something that indicates that they speak Spanish or Russian or whatever language you want, or Japanese, Chinese. It would be ideal if there was something that indicated, you know, what the language was that they spoke on top, like, you know, se habla español or whatever, you know, parlo italiano or whatever you want on top. That's great. Yeah, so that's allowed.
So if they have a sign and they can say se habla español, but could they say for sale in Spanish or pool? So a feature of the house in Spanish instead of just saying se habla español.
You know, there's going to be no hard and fast rule on that. I would, if you were calling me and asking me, I would advise against just having that, because that tends to have one person understand what that is and somebody else not understand it. Okay. So again, if you think that always the purpose of the law is to be inclusive, so if the rest of your sign is in English, right, it says, so everyone knows the house is for sale. And all you're trying to do is say, in addition, I also speak another language. So if you want to ask me about this in another language, great. Then put that up there in that way, but don't just say, you know, then only people who speak Spanish or Russian or whatever else know you have a pool, right?
Okay. If she had a pool in English and a pool in Spanish, would that have covered her?
Like they do in
yeah.
airports.
Yeah. I mean, you could do that. You could, you know, list it, you know,
So if you're
as long as it's in English also.
If you're going to list features, list it in both ways.
In multiple languages.
Okay,
yeah.
all right. What is the best way, in your opinions, for agents with multilinguistic skills to showcase those skills without being accused of violating fair housing?
How to showcase them? Like, give me an example of how they might. You can put them on brochures, you can put them on your website, you could list them, right, all of the different languages or whatever that you speak. You can put them on your card, all the different languages that you speak. You can put them on your signs. I mean, there's nothing ever that prevents you from saying, I do more. Right?
Okay. So if we had a listing and it's in an area that has maybe several different languages being spoken within this area, having English, can we put an ad in the Spanish-speaking newspaper and in the Polish-speaking newspaper? And do we have to do it in all the different languages if we choose one of them? So can I just make an ad in the Spanish newspaper, or if I do that, do I need to go to all the different small newspapers of the different languages that are serviced in that area?
That's a very good question. Okay, so if you are advertising in an area and you want to advertise at a minimum in the in whatever the journal or newspaper or whatever it is that has the widest distribution, and then if you are going to what I would kind of I don't want to call them specialty, but more specific, you know, ones that journals or newspapers or whatever that target, and that's why, and you'll see the issue there, you know, that go to particular demographic groups more, then I would recommend strongly that you go to all, okay? So that you're not just, because you're not trying to steer or target toward a specific group only. because you're going to get yourself into some trouble there if it's like, well, I only want, this group to come over here, but not this group over here. So you really want to be as diverse as you can, as inclusive as you can. Now, if you are getting most, and we don't have that many specific. I mean, if you're kind of hitting the big demographics,
Okay.
you're gonna usually be okay. But
All right.
that's clear as mud again. It's like-
Frequently, we have clients who speak English as a second language or who do not speak English at all. But they will have children who do speak English and they read English.
Right.
These may be adult children or may be minors. And the client prefers to have their children interpret and be part of the conversation, whether they're minor or adult children. It just makes them feel more at ease. Concern is when they insist on their minor child being that interpreter, are we taking a chance of running afoul of the law? Is there a problem there? If there's a problem, how do we insist that they have this outside third party? Because we have interpretation services as part of your benefits of WEMAR. How do we insist that they use that when they really don't want to?
Okay. So it depends on what the family member, we'll start with that, what the
Okay.
family member is interpreting about. Okay, so the way interpretation goes is one, if the person wants that person to interpret, there is some deference given there. Okay? However, it is almost never, unless there's an emergency, okay for the minor child to be interpreting, for the reason that the minor child would not have capacity to contract, right? So the likelihood that they have a real understanding of the terms that you are talking about is low. So it's fine if they're part of the conversation, obviously, making the parent feel more comfortable, but you can also bring in an interpreter. The third part is that the more complex the conversation is, the more you need to have the documents in another language so that the person can certainly understand them, and then an interpreter. So again, it goes to the level of what you're talking about. If they are lending documents, if they're the actual contract that you're signing, then you need to have those in another language if the person does not speak English as a first language, or if they don't, not necessarily even as a first language. I mean, if they just don't have proficiency in English, because English was not my first language, but at least my clients believe I still do okay in English. Don't tell, right? It's like, so it's one of those things where you can do but as long as you have that understanding, it's fine. But I think that's so it's a gradation.
So minor child is just there for
Comfort,
the ease
and comfort. And if they're walking through a house,
Yes,
right?
yeah.
That's fine, right?
Okay.
If they're saying because you're walking through and you're saying this is the bedroom, this is the bathroom, these are the features, whatever else. The child is fine to go through with the parent. But if you're actually getting down to the contract, no.
Okay, so if you're at the contract table and you have an adult family member, does that work? Is that okay?
Excuse me? Yes.
Would that other person have to be licensed if they're going to help in a transaction?
No, not if they're a family member, right? If they're, because, typically that's not the case. You can have a family member sitting next to someone all the time, right, that speaks English, right? And then they give advice and they discuss it. So that's not, it's just a question of, if it's an adult and the person wants that person to do the translation, and that is clear.
Okay.
And frankly, I would have them sign something to that effect, that they want that, right? Then that's fine. But I would strongly advise that you have something that says, you offered a translator, you offered and I would still offer the documents, especially if it's in, if you have the ability to produce the documents in the language, I would absolutely do that.
Now turn it around where I won't understand what the translator is telling the buyer. So what if they explain it differently and we don't know that? And can they come back on us and say, well, you didn't tell us that?
Well, you have it in both, right? So the translator is hearing what you're saying in English. I mean, that's always the case when you have a translator, right? So, and that happens in court, and it happens whatever else. I mean, that's how a translation works. So,
That's true, but
yeah.
if we're sitting there, we don't know what they're telling them. A lot of
So
times I
because
think
you're-
about that when they're translating. People say what the other person
So the concern is the interpreter misinterprets, and that ends up putting but we're still liable for the transaction. How do we?
Well, you
don't-
have the translator, you can ask for them to say it back to you,
Okay,
right? As you would anything where you think there's a miscommunication,
okay,
right? So if you're not sure, you could say, that's an important point. Say that to the translator, right, to the interpreter. Say, can you tell me what they understood, and then have them repeat it back to you, so that you're comfortable with the translation. Because there are, fine points in translations, and I hear them all the time when I. So I mean, it's a good point, but just have them go back and forth and make sure that you have good translators, because that is, if you're offering the service, make sure they're good.
So as
Yeah.
part of your member benefits of Weimar, there is a translation service you can access. So go to the weimar.org website, weimar.org, and you will find the information on the translation services. We're going to move to medical marijuana. It's legal, but landlords and property managers have a lot of issues with this, obviously, because of the conflict between state and federal.
So what I'm going to do is I'm going to talk about first at the state level and then at the federal level.
Great.
So at the state level, there have been a couple of court decisions that are relevant, and then there's also been some efforts by legislative members to try and work on this issue. But particularly with regard to courts, the courts have said in Arizona that having a medical marijuana card is not a defense to driving impaired. And it is, if they smell marijuana on the person, even if they have a medical marijuana card, they can be tested. So the courts have started to create a little bit more clarity there. In Arizona, we're the strictest law. There's about 12 states that have regulations preventing or basically allowing the law enforcement to pull somebody over if they have a metabolite, to test them for metabolites. Arizona's got a no tolerance policy. So with regard to that, there are court decisions trying to make inroads. The legislature recognizes that something needs to be done, but the problem is that it's a politically very dicey issue. 2 years ago, Senator Kimberly Yee, who is the majority leader, convened a group of stakeholders, and what they talked about was ways to try and better get convictions for people who have metabolites, even if they have a medical marijuana card. The law enforcement representatives were very opposed to it because the technology is not there yet to get an accurate read on metabolites. They can have been consumed, smoked or eaten hours before, 12 hours before, and those metabolites are still in the system because they're long lasting. So their concern is that they would have too many people be able to walk away from those from convictions. So what they're waiting for, what law enforcement is waiting for, is a better test, a more accurate test. I don't know how close that is. Some people say it's a few years off. Others say it's virtually impossible to get because of the brain and the fatty areas of the brain. So in terms of that law enforcement surprisingly doesn't want to move ahead with some kind of better regulation of that. Turning to what you can or cannot do in your premises. So you have a lease that says no drugs or criminal activity. If you have that and somebody is smoking marijuana, then the problem is they have their medical marijuana card. But if your lease says, because at the federal level, and I'll talk about that in a minute, it is still a criminal activity. So under your lease, if it says no criminal activity, then or no drugs on the premises, then you have arguably an ability to to evict that person. If, however, you don't have something that specifically says that you cannot smoke marijuana or have marijuana, but you have complaints from neighbors, you can give the person the opportunity to correct that because they have a medical marijuana card. So you've notified them you cannot, smoke marijuana on the premises. If they then comply with that, then the problem's solved. If they don't, if they continue to do it in violation of the lease, then you could pursue eviction proceedings for that. But so that's at the state level. But let me talk generally about what's going on at the federal level, because it really does impact what could happen here, especially under this administration. The Attorney General, Jeff Sessions, is opposed to legalization of marijuana. And so there is in the current budget, there is a bill that has to be approved that basically what it does, it's part of the funding and the 2018 budget, the federal budget. But what it says is that in order for Congress to get this money, they're not going to use those funds to actively stop the production, the distribution, or the use of medical marijuana. It is only to be used for enforcement of minors who get it, or for driving issues and things like that, but not for production or distribution or use. So that is due to expire at the end of 2018. The thought is that it will be passed again and will continue, and that it will not be dropped from the budget because of the tension among the states. 20 states have passed medical marijuana laws. 4 states and the District of Columbia have passed recreational marijuana. So there's a feeling that in Congress that the states want it and that they need to leave it alone for now. However, on the other hand, Jeff Sessions is strongly opposed to it. Now, he and the president have had some tension. So it's possible that the president may support him in order to kind of resolve those tensions and say, okay, we're not going to include that 2018 piece of legislation. We're going to let it expire. Or alternatively, Sessions may prevail, and there is a list going around in Congress for people to sign in support of it, for legislative members to sign supporting continuing it in the budget. If that doesn't get enough signatures, that also signals to leadership in the House and the Senate that there isn't support for it, in which case Sessions might prevail. And this is all unfolding right now as we're speaking. So it really could go either way, but an educated guess and what people inside the Beltway seem to think is it's going to continue because it's been passed by so many states.
So here's our concerns. We have landlord concerns and we have buyer agent concerns. So landlord concerns are someone's going to come into my property, they're going to smoke medical marijuana, something's going to happen at some point, and the feds are going to wake up and today to decide they want to enforce Schedule 1, and they're going to seize my property.
Right.
On the buyer's agent transaction, reading through that huge chunk of law, it appears that because you have the Schedule 1 drug, if you have an FHA or Fannie or Freddie government-backed loan, that's government funds, that technically the government could, once again, something goes haywire, you smoke medical marijuana, they can swoop in and take your house. That puts us in a position of what do we let our buyers know? You're getting a federally backed mortgage, just be careful about the whole smoking marijuana thing. You're a landlord or a property manager, just understand that if your tenant does this, you may have another issue. How do we help our clients? How do we make them aware, but not make them aware if we shouldn't make them aware because we don't have the expertise? But we don't want to be accused of holding anything back either. So we sort of have a double-edged sword here.
It's a murky area, and
Yes.
and on the landlord side, you want to make sure you've met with your attorney and you have that right information in there, and that's the kind of thing that Bruna can help you with to make sure that your leases have the right information. Really, it's all spelled out in the lease, so that's what you're going to go with, and you can't guard against the feds changing that. I mean, it just is a risk that property owners run.
Or enforcing or not enforcing, and that's our
right.
biggest problem. Someday they could wake up tomorrow and decide to enforce
That's
it.
that's absolutely right. But given what's going on in D.C. and the number of states that have approved it, I think an educated guess is they're not going to.
So what about our buyer's agents with the federally backed mortgages? Do they need to be concerned? Do we need to let our clients know that they should be concerned as a due diligence, as a buyer due diligence task?
Right.
A buyer, understand this is something you want to look into. You could be running a risk.
Right. Again, I think you want to really apprise them of that. I think
Okay,
that.
we do. Okay.
And Bruna, maybe you can speak to this a little bit.
Yeah, I think it is a mess. And I think that what I would recommend there is that they speak with their lender,
Okay.
because the lenders know very clearly that any money that goes through them that in any way touches, unfortunately, marijuana ends up being at risk. And so I can tell you that lawyers are also very, very careful about being able to provide advice. Because, again, you're not able to, because there are the threats that they will come in and actually take over even, the law firms and the like, because of the, if we're giving advice on medical marijuana and the like. and so it is, state banks are the way to go.
That's it. That's it. Exactly.
What can I tell you? It's like, hey,
It really
but and I'm glad this is on tape. so if they swoop down in my house, but yeah, I would recommend that they get that kind of advice from their lenders, because I don't think you as the realtors want to be giving the advice on the financial side necessarily. They should talk to. You should tell them, there are some issues here. You might want to speak to your lawyer. You might want to speak to your banker to see how they're handling these issues, if this is a concern for you.
I think Bruna's exactly right. You want to apprise them of the issue and then direct them to who they need to talk to.
Yeah.
How many people actually tell their agents, I have a medical marijuana card?
No, you may not know. You may want to just say something just generally to your clients, like we just make this as a generalized statement. We have absolutely no idea who does and who doesn't, right? But in the event that you are, that you use medical marijuana, or recreational marijuana, just be aware that this is something that you may want to talk about with your lender or your attorney if you choose to, because this is a really murky area and enforcement is changing. Okay, something like that.
When you have that buyer due diligence conversation, you need to inspect the house, inspect the roof. This is another thing. Put in that list of things you need to do as a buyer as part of your due diligence.
You might just want to say it. And when you talk about one thing with the rental and with the employment stuff, it comes up that some people, and what we talk about in rentals is that instead of the smoking, right, they can actually be taking perhaps the pills or the oils or the things like that. And so those are. And that is more easily handled, than the smoking. And if you don't, the easiest way to handle the smoking is to have an across-the-board no smoking policy. And of course, then you have because this can be an accommodation. The question is, the interaction between the accommodation for disability and that. And unfortunately, right now, you have a conflict in the federal laws. Because under the ADA and the federal law, you should make a reasonable accommodation, but at the same time, you have a federal law that says that this is an illegal substance and that there is no this cannot be a prescription. So under the state laws, you're okay. Under the federal laws, you're not, and lawyers can't give you advice, and so it's all just a happy mess. Yeah.
We're getting pretty close to crossing HIPAA lines, aren't we, by asking people personal questions about their medical stuff?
That's why you're not asking. You're not asking. Remember, I said
You don't wanna
no.
ask.
You do not
Do not
ask.
ask.
You say just generally.
Yeah.
We don't want to know anything about you, right? I have no interest.
Okay, well, we're asking,
Right,
what's
right.
your problem with your service animal? Do you smoke dope?
Well, we're not.
No. Again,
The marijuana question goes as part of your buyer due diligence conversation. You're going to inspect the house. You have the right to inspect the house and hire an inspector. You have a right to inspect the roof. You need to know that if you're a medical marijuana user, then you need to talk to your lender and your attorney about the ramifications of that. You have the right to find out if who your APS, if it's your APS or SRP. It's part of that whole long list of buyer due diligence.
right. If you want to,
issues.
if the buyer wants to, if the buyer says I have no interest, You know, that's their deal, right?
Right.
But that's just
Their
something, it's
choice,
just kind of a heads up, right?
Yeah.
And when it came to the service animal, again, you are never, ever, ever, ever asking about their specific medical condition, right? You are,
Just asking about what the service animal
does, right?
Yes,
Right.
yes.
And the letter that comes back, right, is just connecting what does the service animal do for you, right? There's a disability, what does the service animal do? And you're staying away from all of those other, questions, and you never go to like, well, what do you need that for? My Aunt Sally had that and didn't need that, right? No, no, you stay away from all those kinds of things.
All right, we're
You
gonna,
had a question back there before you.
all right, we,
Yeah?
yeah.
Answered?
It was the same question as previously asked.
Okay.
Oh, perfect.
Okay, great.
Yeah, no, exactly.
All right, we are up on the hour, so we are going to take a 10-minute break, and then we'll come back and discuss ADA.